Welcome on behalf of Division 1. This is the May 2022 Toolbox Talk Series. We have our committee member, our TTS committee member, Jen Millender, the Director of ADR Services for the AAA in Boston, Massachusetts, running this show, and she will introduce our discussion leader, Neil Eisman. Thanks, Jen.
So good afternoon. Good afternoon, everybody. As Tom said, I am a director in the construction division, ADR, Division 1 member, and I have convinced Neil Eisman, one of our very esteemed arbitrators and mediators on the AAA panel and longtime construction attorney in New York, formerly with Getz Fitzpatrick, and he is the president-elect of the College of Commercial Arbitrators. So congratulations on that, Neil, and thank you very much for joining us this afternoon. Our discussion today is, your arbitrator and mediator are the same person, and is this ever a good idea? Sort of a topic I think most of us can relate to on one side or the other. Everyone really here being in construction, you've had situations where you had a mediation, didn't settle, and you perhaps decided to have your mediator act as your arbitrator, or you were arbitrating and got to a point where you thought mediation might be beneficial, and maybe you asked your arbitrator to be your mediator. And Neil, having been both mediator and arbitrator, what are your thoughts on switching from one role to the other? Is that a good idea, and how do you do it effectively?
All right. Well, hello, everybody. My pleasure to have, I hope, a conversation with everybody as opposed to me talking for 29 and a half minutes. Jen, thank you for pointing out that I'm a dinosaur. I appreciate that. We'll talk about that privately later. So we're talking today about something that people in ADR, they refer to as quote unquote mixed mode. And it's really something that it's happening. It's not happening as much in the United States as it is outside the United States. And I think it makes sense maybe to define some terms to make sure that we're all on the same page. So I think there are really two situations. There's a situation, let's say you have your mediation, and it's not going well. You're representing your clients, and let's say the default is arbitration. The arbitration box was checked in the underlying contract, and the clients get together and the attorneys get together, and it looks like it's inevitable you're going to arbitration. And everyone says, you know, that mediator, we like that. We like him or her. We want that mediator to be our arbitrator and to decide the case, and we'll have an arbitration. So that, of course, is known as med-arb. Makes sense. Mediation, arbitration. The notion here is that the same person or individual is both the mediator and the arbitrator. Now, we know that's not normally the case. Normally, you have a different mediator and arbitrator. Okay, so that's the first concept. The second example is really just the flip. Let's say that the parties, for whatever reason, haven't mediated, or they did mediate, it didn't work, and they're in arbitration. They have a sole arbitrator, and both sides are scoring points during the arbitration, and they're thinking, you know, it's probably a good idea to try to settle this case and not go through with the arbitration, or at least give it a shot. But we would need a mediator. Whoa, wait a minute. We really like how that arbitrator's been handling the let's ask the arbitrator to become our mediator. We'll hold the arbitration in abeyance. And if God forbid we can't settle the case, well, then the arbitrator will continue. But we want that arbitrator to be our mediator. And that, of course, is arb-med. It's just the opposite. So I am curious, have any of you been involved where you've represented clients where you've done a med-arb or an arb-med? Anybody had that experience? Patricia, have you? I had a feeling, but go ahead.
Well, I had it come up when I was an advocate, and we settled a really complex case with counsel who could not agree on the time of day. And we had this long settlement agreement, and then all of a sudden the parties didn't agree on what it meant. And we turned to the mediator and asked the mediator to tell us what it meant. I've since learned in my training, that's not really the mediator's role, but we didn't know any better. Mm-hmm. And that often is how people stumble into these situations, is they just don't know any better.
Yeah, it's true. And, you know, when we're sometimes it comes up in the clients because, you know, the clients, they don't have the legal training, God bless them. And when they like somebody, they figure, well, why not? We already got that person there. I have confidence. Let's let her rip. But they have to have their eyes wide open about the consequences and the significance of either doing meet arb or meet. I think, you know, when you think about it, it's really, it's sort of a blending or an amalgamation of two different ADR processes. Mediation. So we all know mediation, the mediator has no power. It's unethical for the mediator to be coercive. And, you know, the mediator either facilitates or, if asked, may be evaluative. But the bottom line is the mediator is not calling the shots. And as we all know, any party can just say no. Arbitration, totally different. Arbitration's got all the power. The arbitrator, rather, has got all the power. They're going to call it as he or she sees it. And I think an initial criticism of mixed mode would be, does it really recognize perhaps a fundamental incompatibility between the role of the mediator and the role of the arbitrator? And the next question that I would ask is, even if the parties are well aware of that, do they care? Is it better? Does the marketplace require, in some cases, that, you know what, let's just have the mediator become the arbitrator or the arbitrator become the mediator? Well, in order for you to really have a conversation about that, you got to understand what the pluses and minuses are with having a mixed mode. And, you know, why would the parties seriously consider that? So I think it makes sense maybe to have a conversation about, let's talk about the possible pluses of, we could stay with meet arb, it really doesn't matter, just as an example. Again, you have your mediator and there's the notion out there, we're not going to settle the case. Let's have the mediator become our arbitrator in a binding arbitration. So anybody have any idea why might you agree to have a meet arb? What would a positive be? I hope somebody can think of some positives. Otherwise, I don't know why we're talking about this today. But anybody have any suggestions or let's brainstorm?
I can think of a couple of positives, and it's one we strive for with the dispute resolution board, is that you are building the expectations on how disagreements are going to be handled and making them more systematic.
Okay, very good. And you mentioned another, perhaps?
I think one would be saving time and money. You've
There you
already done the dog and pony act in the mediation. Why do you have to do all that again and take longer to do it, which you would have to do in arbitration?
Also get the informality of mediation to get the information to be exchanged in a much more collaborative and dynamic way. And then the arbitrator can zero in on the specific issues that he or she really needs to make the decision.
Yeah, good points. Anybody else have any other thoughts as to why it might make sense to do in our example, a meet arb?
I can weigh in on an experience I had. So,
oh, please, I'd love for you to do that.
So I had a 2-day, arbitration, small matter, and the parties last minute decided to use the first day, or make it 3 days actually, and use a day to mediate with the retired judge who is the arbitrator. And for all the reasons that everybody's already stated, maybe we didn't have to spend all the money on a full-blown arbitration, that, it's a small matter. Let's just try to, get this done. In that case, it didn't work out so well for us. We did not agree at mediation. And it became evident throughout the arbitration that the judge had developed some sympathy for the opposing party, and even called them the victim. And it was a breach of contract action. So there's no real victims there anyway, at least in my opinion. So it didn't turn out well in that case. I'm not saying that it given the right neutral, it may have been a little better, but that definitely was not.
So Catherine, it's interesting. Do you think you agreed and your client agreed to do it primarily because of the size of the dispute? You mentioned it wasn't a large dispute. Is that a factor? Because that to me, I'd like to hear what your thoughts were at the time. If it had been a $3 million dispute, is that something that you might not have gone forward and had a mixed mode? Was that a consideration?
Possibly. I think it had to do with the distance that the parties were apart in terms of the dispute. And so because it was already a small matter, they were not that far apart to begin with, even if one party was at 0. So, you know, if we had, you know, prior discussions in a $3 million matter and we were only, you know, a couple $100,000 apart, then yeah, I mean, I would say, why not try to resolve it before a full-blown arbitration?
Okay.
And if I can ask a question, and it does relate, excuse me, to Catherine, the experience you had, it's in that sense, you go, well, maybe it's not a great idea to have your mediator become your arbitrator, because they may have developed opinions based on information that's provided in a mediation that you would not necessarily provide to your arbitrator. So how is the neutral, how do you make that switch and not try and develop, as she said, the judge did, sort of a preconceived notion? How do you avoid that?
Right. And that's something I want to talk about a little later, Jen. That's an excellent point. I mean, look, when you hear we're all human beings, I think. And when you hear something as a mediator, it's very difficult for you to say, I'm not going to consider that or remember that when I'm the arbitrator. I mean, maybe some people can decompartmentalize like that. But, you know, there are a lot of studies done on implicit bias and all of this stuff about subconsciously, your opinions are formed based on things that you don't even know you're considering. So there's a lot out there saying that it may be difficult, despite the best intentions of the mediator, when the mediator is the arbitrator, to disregard information that was given to them privately and in confidence during the mediation that they would never see during an arbitration. So, you know, your point's well taken. And Catherine, it sounds like you experienced that firsthand. So.
Yeah, and I guess maybe not make lessons learned, maybe not make that decision the last minute. You know, if you're thinking about doing something like that, you know, try to do it well beforehand.
Right.
Not the day before the arbitration.
On the same point, you know, if you did plan ahead to do a meet arb, I'd be concerned that the neutral is not going to get a fulsome relationship building with that person, because that you're going to be concerned about what you're going to share with your mediator / arbitrator, and now you're losing the functionality and the efficiency of a mediation process.
Yeah, you are. You know, it's interesting. So what we're supposed to be talking about right now are the positives, and we're talking about the negatives, and that's important. There are a lot of, this is a new thing, and I've had conversations with fellow neutrals where I've said, hey, I would never do a meet arb or an arb meet. There are plenty of other neutrals out there. I don't need the business. I don't need to do both. And the truth of the matter is, I don't necessarily think I can be fair. I'm not perfect. And it may be I can't get out of my head what I learned in mediation. And it may have some effect on my evaluation on the merits of the case when I'm the arbitrator. And the response of a lot of my friends are, Neil, that's what the marketplace requires. Get over it. And I'm like, I'm not sure I can get over that. Okay. We'll talk about one way I might be able to get over it before our 30 minutes is over. So anybody have any other thoughts about any other positives to be gained? You know, realistically, the client may just want to do it. And the client may not want to listen to you because they just have so much confidence in, again, if it's meet arb, in the mediator, and they're getting good vibes. And, you know, it may be that despite what you tell the client's all totally concerned about money. They know they're not going to have to have an attorney prepare for another proceeding. It sort of rolls into the mediation into the arbitration. They know they're not going to have to, they're going to end up saving time and money, which are very important to business people. And they may override what your advice may or may not be to them regarding whether it's a good idea.
Neil, can I just add, if all you need,
Patricia.
if all you need is a legal decision, in other words, it's not a question where the mediator may know some secret facts,
Mhm.
but the facts really aren't in dispute, the parties just can't agree on what the judge will likely rule, then I think that is a cleaner case to
Mhm.
have the mediator become an arbitrator, because the law is the law.
Yeah, your point's well taken. I think that, most disputes, construction disputes, whatever, usually they're fact sensitive and it's battle of the experts. So it's rare where everyone would agree that there's only one legal issue. Oh, is the pay when paid clause enforceable? Whatever, it doesn't matter. So that's more the exception, but I think you're making an excellent point. You have to look at the nature of the dispute and you have to look at the amount of the dispute. They may be factors. So the things that I wrote down, I'm looking at my piece of paper in terms of the positives. Number one, if you're going to do it, it does combine the best of both mediation and arbitration in the sense that you do get a possibility of an early settlement. The mediation is successful, and you do get the finality that you'll get in arbitration if it turns out that the mediation didn't work and the mediator then becomes the arbitrator. Cost effectiveness. This is what I addressed a couple minutes ago. It's really important to clients. What does it cost me? What's it going to spend? And, you're not going to have the duplication of expenses, arbitrator, attorney's expenses, getting the arbitrator up to speed. Your mediator is up to speed. So therefore your arbitrator is probably up to speed. It's the same friggin' person. And understanding the parties' disputes, it flows from the mediation into the arbitration. It saves time. It's going to save time. There's no doubt about it. You're not having to select a new person. And that's also, I guess, the cost consideration. And again, another reason may be what I alluded to, that the parties really trust the neutral. They think they have the right person, and they really believe that that person's going to get it right. And they'd rather roll the dice with that person, the devil they know, or the person they know, rather than select a different person for the second part of the, in this case, for the arbitration. So the negatives, that there are a lot of interesting negatives. And I would say, look, with mediation, it really requires, if it's done correctly and you have attorneys who know what they're doing and they know it's confidential, nothing can come back and bite them if you don't settle. No one's going to testify what happened in a mediation session, in an arbitration or a subsequent action. Mediation really requires the parties to be candid. And in doing so, it'll be ex parte, and it may be just for the mediator's ears and eyes only, but they're going to reveal sensitive information, which can include their bottom line positions. It can include bottom line numbers, et cetera. And is that really something you want your arbitrator to know? Thoughts? I think the answer may be no, but thoughts? Do you really want your arbitrator to know what your bottom line is, that an arbitrator would never know if they weren't your mediator before? It's an important consideration, isn't it?
Right.
Yes. I talked to one of the counselors I work with regularly, and she said exactly that. That was her big concern, is that they would know what number you were looking at before you got to arbitration.
And, Robert, I mean, again, so if I'm the mediator and then the arbitrator, and I know what your client's bottom line is, am I good enough not to let that affect my thinking and my deliberations and my bottom line when I'm doing an award? I would hope I'm good enough, but do I really want to be in that position? And I will tell you, depending upon who the neutral is, some neutrals have no problem with that. And others, they're going to decline. They're going to say, get yourself a new arbitrator. It depends on the person's style, whether the parties want it or not. So it's kind of interesting. I think that knowing that the mediator may become the arbitrator, it can affect the ability of the mediator, before the mediator becomes the arbitrator, to get the case settled, because it may be that the parties are less likely to be open and candid, knowing that if the case doesn't settle, that arbitrator is going to know this information and that information. Maybe we don't want him to know that because that's really not our position when we're trying to win the case in arbitration. That's a really, really big issue. And let's face it, everyone on this call I know is experienced. If you know you're doing meet-arb, are you likely as an attorney representing a party to try to spin before the mediator, or try to, I'll use the word, manipulate the mediator so that when you're in arbitration, you have a better chance of winning? I mean, this can get metaphysical, okay? you may, and is it in the best interest of your client to do that? If you know the case isn't going to settle in mediation, and by the way, if you say no, you know it's not going to settle. Well, then are you really using the mediation to work over your soon-to-be arbitrator and be selective about what you tell him or her? You know, then it gets into a lot of gamesmanship. That possibility is out there. We also discussed, can the mediator really truly be objective? The mediator is given confidential information ex parte. You know, I think there's an argument here that perhaps we shouldn't have an overreaction to that. And I'll lay this out. I'd like to get some quick reaction. Let's assume you're doing a bench trial. Forget about arbitration, mediation. Forget about ADR. You're doing a bench trial. And a couple things happen. Before you go in with the judge, and this has happened to me, and I'm like, is his or her honor really having this conversation? They try to get the case settled, and they ask you for your settlement position. Case doesn't settle. You now have somebody deciding your dispute who knows what the settlement positions were. So is that really, I'm not saying that's appropriate, but I know it happens. It happens a lot in New York and New Jersey. Is that really any different than what we're describing with having a mediator here with the bottom line settlement positions are, and then becoming the arbitrator? Another example, you're at a bench trial and certain evidence has come out, and then there's a motion, and the judge ultimately decides, you know what, it should be excluded. Or something comes out and there's an argument about privilege, and the judge says, you know, it's privilege, but the judge has already heard that stuff. Is the judge able to disregard that when he or she is rendering their decision? Again, assuming it's a bench trial, is that really any different than med-arb? Any thoughts on that? It's interesting, isn't it? I mean, I will tell you, I think it's wrong if a judge is going to be the trier of not only the law, not only deciding the law, but the facts, for a judge to have settlement discussions. But I'm telling you, it's done. It shouldn't be, but it's done because judges want cases, you know, standards and goals. They want them off their docket. You're in federal district court, the magistrate will probably handle that, not the judge. But, you know, this stuff does happen at times. And you know, I know from experience, they write on the docket sheet what the numbers are, and then the judge gets the docket sheet. And they see what the numbers are. I know that. I've spoken to judges about that. So I don't know whether that's any different. Anybody have any thoughts on that?
It seems exactly the same. It's the number that's going to stick in their head.
Mm-hmm. Yeah, it's something to think about and to advise your client, I think. There are situations in ARB-MED where you go to arbitration first. The arbitrator then seals his or her award and then becomes the mediator. Mm-hmm. And the award is only unsealed if the arbitrator turned mediator doesn't get the case settled. Has anyone had any experience with that? It's done. I'm not going to tell you it's done a lot, but there's been a lot of studies about this. So here's the problem with that. The arbitrator decides it, X amount to the claimant. Then during the it's sealed. Then during the mediation, the arbitrator, now turned mediator, finds information out that the arbitrator didn't see in the arbitration. And the arbitrator, who's now your mediator, says, you know what, that award that I sealed, I wouldn't go that way now, or I would change it. That creates the possibility for your arbitrator to be a little coercive, to try to quote unquote force the parties to settle, because the arbitrator doesn't, or the mediator doesn't want its prior award unsealed because the mediator doesn't agree with the award that the mediator gave as the prior arbitrator. And again, I use the word metaphysical, but you know, you can get into this stuff, and you know, that's a problem. And there's something else I think that I would want everyone to consider. What you've had ex parte conversations in your mediation. You're now going to arbitration with your mediator turned arbitrator. So I'm thinking, as an advocate, I don't know what private conversations opposing counsel has had with my now arbitrator. I don't know. So I'm not in a position to respond. Maybe there's evidence I could bring out to show that what the mediator was told confidentially is BS. But since I don't know what the mediator was told, I can't even begin to bring it out and do a job for my client. Well, guess what? That sucks. So if that's a scenario and you're concerned, that's something I think you have to talk to your client about. If your client's saying, hey, you know, let's go with the same person here. Again, there are a lot of nuances to this. Now,
Neil, can I ask a question?
pardon me?
Can I ask a question, just really quick?
Yeah, of course
Yeah,
you may. You don't.
so-
You just did. You can ask another one, Tom. I love you. Go ahead.
Thank you.
Sure.
So I've never heard the term mixed mode before, but that makes me think that there's a lot of, you know, publishing and a lot of articles about these topics. Are there some with AAA or other organizations, some guidelines that they could give arbitrators or mediators that say, if you're going to do this, these are the things you want to have in your agreement to, explain confidentiality and the roles of the mediator and the arbitrator during these different phases? Is there any resources that, if not now, maybe you could, send them to us, or Jen, if you know of anything, so we can.
So
put on-
I was going to punt that to Jen. What's the AAA's position on mixed mode, if there is any?
Generally speaking, our position is we don't encourage it for the reasons that have been laid out here. It's specifically the information provided to a mediator on an ex parte basis that you can't really pretend you never heard as the arbitrator, and the issues that can arise from that. So to be honest, it's not something that we encourage. I am not aware of any specific written policies or procedures. It's more of a situation that is addressed if it is raised by the parties, or if a neutral is approached and we have the discussion of, can you truly be switching from one role to another? Can you make the change and still be effective and not have bias? Unconscious, really being careful of what your position is. I unfortunately have seen a situation years ago, case that I inherited from a different case administrator, where the neutral was appointed as an arbitrator. The parties agreed to mediate before him. And then it was, well, if that doesn't work, we'll go back and have him be the arbitrator again. And I said, oh, no, I strongly discourage this. And there was the suggestion of an award and sealing it, as Neil mentioned. And I said, I really just don't think this is a good idea. I don't see how this can flip flop, multiple directions.
Yeah.
And
So-
the sealing of the award that may, as you said, may completely change.
Well, maybe that's a good follow-up for Division 1 to do, Neil, is to come up with some guidelines.
I was going to suggest, yeah, especially if, and we were going to try and discuss, the actual hybrid contract process of mediation arbitration. I think we're not going to have the time for it, but maybe if anybody on the call has seen a clause that calls for the mediation / arbitration hybrid, if you want to,
Jen, I was going to suggest that I just started with the dispute resolution board, and the big difference is they don't mediate. They encourage mediation between the parties, but they effectively act like an on-site arbitrator. So they have to probably go to Tom's point. There's an extensive training in ethics and maintaining your unbiased position. You would never express, well, that this guy's the victim, etc. However, when I go, to your point, it's still, even though they're out on the job collecting facts more extensively than you would ever be able to in an arbitration situation, because you're involved in the project over time and in depth. Still, you're going to get a flavor for how people act on the project, and that's going to be a bias problem that you have to work hard on and stick to the four corners of the contract, is how we refer to it in our decisions.
I'd say in the minute that we have left, a couple things. Jen, there are other providers who will do mixed mode and not think twice about it. There are other providers out there. I know that from experience, not that I'm on their panel, but I know that. Also, to me, I said there's one scenario that might make a difference to me. If the mixed mode is agreed and part of the party's agreement, in other words, their underlying contract, up front, before you have the first mediation, before you have the first arbitration, then everybody has eyes wide open before the first mediation, the first arbitration, that there may be a mixed mode. That's a little more palatable. But when you do it in the middle, you catch the mediator in the hall and say, do you want to be our arbitrator after the mediation? A little bit of a problem there. And Tom, finally, in answer to your question, there are articles out there. I am happy to give them to you. I know Tom Stebanovich has written one, very, very thick one in the Harvard Law Negotiation. I have a copy of it. My friend Rich Silverberg has written on it. I can give you articles and maybe you can somehow get that to our friends. I'm happy to do that offline.
Sure, thanks.
Okay.
I'm actually working with, you said it's Rick Silverberg?
Yeah.
I'm working with him on something, so I'll reach out to him today and see if I can get that article.
Yeah, he did one on Arb Mead.
Great.
So I think our time is probably, I know we have a hard stop, so I'm deferring to everyone else, please.
Yeah, we do, but thank you, Neil, and thank you, Jen. This is a great topic, and everyone for participating in the discussion. Have a great holiday weekend.
Thank you, everybody.
Everybody,
Bye.
thank you all.
Bye-bye.